Okay, thank you. Look, I'm really sorry I can't be there in person. I was hoping to. So according to our Australian Sex Discrimination Commissioner, who's made submissions in the recent case of Tickle versus Giggle, which is a real Australian case, sex is not a biological concept. It's not binary, and a person's sex can be changed. So in other words, here in Australia, women can be men, men can be women, and so much more in between. I appreciate this is not unique to Australia. The whole world, of course, is suffering with this nonsense. But what you might not know is the extent to which Australia has led the way in undermining women's sex-based rights. Many people know that New South Wales, Australia, was the first jurisdiction in the world, for instance, to decriminalise prostitution. But fewer people know that we've also been a trailblazer in securing transgender rights, although largely by stealth. So even those of us in Australia weren't aware of a lot of what was happening. But I won't get into all that history now. I'm just going to focus on some of the most recent legal cases that have taken our attention over recent years. Because I'm a lawyer, I have to start with a disclaimer, which is just saying that we've been involved in a lot of the cases I'm talking about, but I'm out of consideration for client confidentiality and in some cases court orders. I am only just sharing details which are really on the public record already. So the next slide talks about CEDAW. CEDAW, I hope everyone's familiar with that term because we do a lot of work or have done in the area of domestic violence. That comes up a lot, that acronym of deny, attack, reverse, victim and offender. And I'm interested in this because I've been seeing this for years, of course, in the field of domestic violence, that the legal system facilitates this behaviour by allowing men to weaponise domestic violence legislation that was originally put in place to protect women. But now we're seeing it in other areas. For instance, sex discrimination laws are now becoming a weapon that is used against women. And so I want to discuss some of those cases. So the next slide talks about the fact that we've got a large variety of cases. It's not just discrimination cases. Our work in defending women's sex-based rights, and we're the only community legal service that I'm aware of in all of Australia that will take on this work. And we're being contacted about cases across many areas of legal practice and from every Australian jurisdiction. So we've got different laws in each state in Australia. And it's extremely demanding for a tiny unfunded service like ourselves that's just entirely run by volunteer effort. So the threat to women's spaces, services and opportunities is one thing, but we've also got children's safety and wellbeing, jobs, careers, leisure activities, our reputations, and all of these things are under attack. So there's a lot happening. So the next slide is about discrimination cases, of which there's been quite a few significant ones. The first one that I'm just going to talk about was actually in our very first year of operation in 2017. We were approached by a newsreader, Beth Rep, she's the first photo there, who had received a complaint against her for vilification on the ground of gender identity by the gentleman with his finger up in the black T-shirt next to her in that photo. His name is Bridget Clinch. He was ex-military and a trans activist, and he brought a complaint about some of her social media posts, 46 of them, in fact, and it was a massive case to have to deal with just because of the pure quantity of material. And it went on for like 4 years, and it was grueling in the tribunal that proceeded at a glacial pace. And in the end, they found that 9 of the social media posts, I mean, this was already on an appeal from the original tribunal decision. They found only 9 of the posts were considered vilification, and only 2 of those were by Beth Rep herself. Despite that, they managed to decide that Beth should have to pay him $10,000. No, originally it was $10,000, but then on the appeal, they reduced it to $5,000 in compensation, which was just, I mean, I first find it breathtaking because in New South Wales, for instance, $5,000 is the maximum amount payable to many victims of sexual assault and violent crimes. So to pay someone $5,000 for a couple of posts that are really marginally offensive is really just so outrageous. The other thing that should be noted is that there are no laws that protect women from offensive comments that vilify them on the ground of their sex. So, for instance, a lot of the posts were not considered with fair consideration of the context. So to give an example, for instance, if a man makes an offensive comment about the superiority of his surgically altered genitals, he's not breaking the law, but a woman who then expresses her disagreement with him may be found guilty of vilification in saying, casting aspersions upon these surgically altered genitals and their failure to match up to the genuine thing. Anyhow, ultimately, Beth decided against lodging an appeal to the court system because, frankly, it's just, there's no guarantee of success and it's very, very risky. And Beth had already lost her job, had her mental health impacted, and she just really needed to be over it. So she said, despite the failure of the legal system to protect women's freedom of speech, she hoped others would find the courage to speak up and defend our sex-based rights. It's hardly a surprise, however, that many women aren't willing to take this on and sacrifice as much as Beth did. So when people talk about winning, I'd ask them to spare a thought about those who fight some of these cases for years and you know, don't win, and yet have put up a valiant effort, and whose attempts to raise public support, for instance, and funds have been hampered by non-publication orders, which is what happened in that case, although eventually it was found that they shouldn't have made those injunctions that didn't really help Miss Beth or undo the damage that was done to her personally or to freedom of speech generally. Now, another case relates to Jessica Hoyle, who's sitting on that bench with her dog. She's a lesbian woman who planned to organise an event in Launceston in Tasmania, exclusively for females. She applied for an exemption to be allowed to refuse entry to males. Her application was refused by the Anti-Discrimination Commissioner. And despite acknowledging that the exemption related to sex, and that's an attribute not actually protected under the Tasmanian legislation, the Commissioner refused the application on the grounds that granting the exemption would permit discrimination on the basis of gender identity. So they're having it every which way. She then applied for the decision to be reviewed by the tribunal, who upheld that decision. And again, we have run into this problem that she didn't have the resources to appeal the decision through the court system because of and also mainly because of also the substantial risks involved if you can't guarantee a win. And Jessica, while that case was going on, had another case arise because she was in a department store, Target, and she was called a TERF and asked to leave the store by a member of staff, which was just extraordinarily outrageous. And again, the Discrimination Commissioner, instead of protecting her from this kind of discrimination in the provision of goods and services, did not uphold her complaint. And again, it went on appeal to the tribunal. Again, no luck. So same story. It just becomes so expensive and risky to take it through the court system with no guarantee of success. And now this brings us to the case of Tickle and Giggle, which is a very high-profile case where it involves a discrimination claim against Giggle Proprietary Limited and its CEO, Sal Grover, who has attempted to create an app that provides a safe space online for women and girls to network free of male harassment, free of men, in fact. However, trans activist Roxanne Tickle, I imagine you can identify him in the photo, he identifies as a female, but is of course a man, but he wasn't having it. And when he was denied access to the app, he made a complaint to the Australian Human Rights Commission, alleging discrimination on the grounds of gender identity. He does, of course, and legally under Queensland laws, can claim to also be legally female. So it's all a bit complicated because if he's legally female. Anyhow, when it became apparent that conciliation would not eventuate, the claim was terminated by the Australian Human Rights Commission, and he then commenced proceedings in the federal court. And then he actually originally abruptly terminated the proceedings, only to recommence them in the following year when he had financial backing. That financial backing is the big thing. The matter was heard in April this year during a 4-day trial, and we're currently awaiting the decision, which, you know, we're all holding our breath on that. There is an expectation that this matter may end up on appeal to the High Court, you know, primarily because the parties may well have the resources to take it further. Unfortunately, earlier cases of the Australian High Court have already made some decisions in which there's been an acceptance of legal recognition of change of sex. So the High Court really needs to overrule its earlier decisions in this area to uphold women's sex-based rights effectively. And the final case, there's a picture of Carol Ann, who's a member of the Lesbian Action Group, who brought a case against the Australian Human Rights Commission. And this involves a group of lesbians applying for an exemption to hold events exclusively for female-born lesbians, effectively excluding men who are claiming to be lesbians. The Commission rejected the application, stating that it was inconsistent with the principles of the Sex Discrimination Act, and the decision's now on appeal to the Administrative Appeals Tribunal, and it's going to be heard on the 2nd and the 3rd of September this year. So just watch this space. The next slide is about medical negligence cases. That's a picture of Jay Langadinas. Her case received quite a bit of media attention. She's an Australian woman who filed a lawsuit against her former psychiatrist, Dr. Patrick Toohey, and other treating health professionals. She alleges that he approved her for hormone therapy and surgery as part of gender transition without adequately assessing her mental health or exploring alternative treatments. She underwent hormone therapy, a double mastectomy, a hysterectomy between the ages of 19 and 22, procedures that were not in her best interest and have caused her significant harm, and she's claiming medical negligence and is seeking damages. I often hear people say that things will change once the medical negligence cases really take off, and indeed, we've already seen one medical insurer in Australia pull out of insuring doctors who provide gender-affirming services. I often hear people say that things will change once the medical negligence cases really take off. And indeed, we've already seen one medical insurer in Australia pull out of insuring doctors who provide gender-affirming services. However, successfully bringing these claims is beset with difficulty, not the least of which is for the clients to be psychologically ready to engage in the litigation process within the narrow time limits set for personal injury actions. Another difficulty is that the standard of care for professionals is that they must act in a manner that is widely accepted in the opinion of their peers as competent professional practice, unless it can be established that the opinion is irrational. And unfortunately, it's quite difficult to find doctors willing to act as expert witnesses and to state that their peers have been negligent, or let alone that they've acted irrationally, which is what in some cases might even be required. And it's also difficult to find law firms who are going to run these cases in view of these difficulties, and their concerns also about their reputation. So that's some of the difficulties that we have with those cases. So then to the family law. The family court's done a lot of damage. There was an early decision in 2001, re Kevin, in which Kevin was accepted by the court to be a man and allowed to marry despite having been registered as a female at birth. I mean, at the time, that probably seemed a kind decision to make, but of course, as we know now, the implications of these decisions are far-reaching. So then we've had a string of cases, re Jamie, re Kelvin, re Matthew, which have progressively removed the need for court approval for the use of cross-sex hormones and surgeries in the case of children wanting to change sex, if they're regarded as Gillick competent or capable of providing consent. Now, in re-Imogen in 2020, the family court has walked this back slightly, and they've kind of decided that if there's not consent by both parents and the doctor and the young person, then in that case, it has to go back to the court. So that's a slight improvement in that if there's one parent willing to oppose it, it's got to go to the court through the court system. Of course, unfortunately, the court system tends to approve these medical interventions. So it's only a modest departure from earlier rulings, but enough to get criticism from our Australian Professional Association for Trans Health, which is always a good sign. There's another case which is currently before the courts, again, a family law case where the parents are divided over whether their daughter should medically transition. This is a case where the court heard that the child's 10-year-old sister had made a pact that she would one day harvest her eggs so the sibling could have babies. again, there's such strict suppression orders that relate to all these cases that you can't even report the parent's sex or the name of any of the treating doctors. Barrister Bell Lane is acting for the parent opposing the child's transition and has led evidence of the CAS review despite much resistance. Again, in these proceedings, an application to intervene was made by a group with concerns about the use of the hormones and surgeries, but this application was again refused and details of the group has been suppressed. And so we've just had the closing submissions in that case and we're waiting that decision. So the next slide is about unfair dismissal. Try to go a little bit quicker. Look, we've had so many of these cases come to us. There's so many women who are being sacked or have had their employment or career threatened because they've questioned gender ideology in the workplace or even in a private capacity. Teachers, public servants, social workers, academic students, health professionals, fitness instructor, journalists, legal professionals. I won't even try to go into those many cases. There's a couple of pictures there of matters that actually have been publicly reported. And, you know, one of them is Jasmine Sussex, who many of you will be familiar with. She's a volunteer breastfeeding counsellor and she claims she was sacked for hate speech, for continually using the word mother. Mother is now hate speech. Jasmine also claims to have been censored for posting on Twitter that men cannot breastfeed and is most recently facing a vilification complaint under Queensland discrimination laws. And there's likely to be more to report on that case in the future. And there's another photo there of Pearl Moon, who was expelled from an art festival after organisers discovered she had spoken at a Let Women Speak rally. And Pearl is a mixed media artist who works in textiles and creates wearable works of art, as you can see in that photo. Fortunately, following intervention by our service, Pearl was eventually able to exhibit her work as a finalist. The next slide is about defamation cases. And it's about Moira Deeming and John Pursuto. Moira Deeming is a member of the Victorian Parliament and she's got a defamation case currently against the leader of the Victorian Liberal Party, which is our Conservative Party, John Pursuto. And it's expected to be heard, I think, fairly soon during a 2-week defamation trial in Melbourne. Pursuto issued a press release and conducted various interviews, circulated a dossier, and is responsible for an expulsion motion, all of which Deeming alleges painted her as a neo-Nazi sympathiser and ultimately resulted in her being ousted from her parliamentary party. And this all arose out of Moira's attendance at a Let Women Speak rally in Melbourne, which was gate-crashed by neo-Nazis. Organisers Kelly J. Keane and Angela Jones from Australia have also brought some defamation action, but their matters, I believe, have already been ended in a confidential settlement with an apology issued by John Pursuto. And the final slide is about criminal law cases. I mentioned there's a case of Riley Dennis and Kiralee Smith, which is an example, again, of Australian laws being used to silence women who speak out. I believe Dennis had brought both proceedings for protection orders and a claim of vilification against Ms. Smith, but I understand she successfully defeated all his claims. And then there's the case of a woman in Melbourne who suffered a broken shoulder resulting in permanent impairment following a brutal attack by a trans activist, apparently as retaliation for her gender-critical views. The trans activist's name was Sarah Cadzow. I won't name the victim, but she identified the perpetrator to police. She provided witness statements and reported the matter promptly, but there was a delay of months before the Victorian police finally charged him with assault. And when the matter finally went to court, he was found guilty only of a common assault and received no conviction, only 5 months good behaviour bond, ordered to pay a small amount. So, look, I'll finish it there. So that one's a great example of what I began speaking about, Davo. And apologies for my coughing and loss of voice partway through. Thanks.